contentions regarding the credibility of the results as issued in the declarations of poll, especially that for District Number 4. As a result, GCOM decided to undertake a recount of the votes cast. Indeed, in the contempt proceedings that were instituted as a result of Holodar, the Holodar case, the chairperson gave an undertaking about the tabulation of the votes, that the tabulation would be completed in accordance with Section 84, and that if there were discrepancies, then GCOM would facilitate a recount. This is captured in the decisions in the Ulitimore case. The process and procedure for the recount adopted by GCOM were included in an agreement between the two major political parties in Guyana, led by then-President David Granger and the then-leader of the opposition, Bar Jagdew, which agreement was brokered by Prime Minister the Honorable Mia Mottley of Barbados, then chairperson of CARICOM. The decision to hold a recount was challenged in Ulitimore on the basis that GCOM was abdicating its responsibility and control of the recount process due to external intervention. In this case, Justice Holder granted injunctions restraining GCOM from proceeding with the recount. The decision to grant the injunctions was appealed to the full court, which allowed the appeal and discharged the injunctions. This decision was in turn appealed to the Court of Appeal, which allowed the appeal in part, but ruled that the injunctions remained discharged with the admonition that GCOM was to be in control of the recount process. The decision of the Court of Appeal in Moore ultimately paved the way for GCOM to issue Order 60. In accordance with the order, the process saw a recount being conducted of the ballots cast in all 10 electoral districts. The results of that recount process were recorded on documents named statements of recount. The statements of recount were to be tabulated to produce the result. Subsequent to the completion of the recount, there continued to be contestations, and despite repeated written requests by the chairperson of GCOM, the CEO did not submit a report to the Commission that was based on the statements of recount. This resulted in further legal proceedings filed directly to the Court of Appeal by the case of Eslin David and Chief Elections Officer and others. In David, the applicant relied on the validity of Order 60 in advancing that there was non-compliance by GCOM with the said order in the conduct of the recount. Ironically, counsel for the petitioners who now challenge Order 60 was counsel for the applicant in David. In a majority decision, the Court of Appeal ruled that Order 60 required that only valid votes cast should be counted for the purposes of a declaration of the results of the election pursuant to Article 177 of the Constitution. On appeal, the Caribbean Court of Justice, the CCJ, overruled the majority decision in David. That would be in the case of Ali and another, and David and others, and nullified a report dated March 13, 2020, issued by the CEO, in which he presented results of the election. This ultimately led to a ruling by the chairperson of GCOM, which directed the CEO to submit his report based on the statements of recount. But before the CEO submitted his report, the storm of the election saga, as I described it in Holodar, continued with the filing of further proceedings in the High Court. This case was Missinga Jones and GCOM and others, in which the applicant challenged the constitutionality of Section 22 and by extension Order 60. It was contended in this application that as a consequence of the unconstitutionality of Section 22 and Order 60, the recount results were invalid, and that only the declarations of polls submitted by the returning officers could be utilized to determine the final results of the elections. This court ruled against the applicant, and on appeal, the Court of Appeal upheld the decision to dismiss the application, holding that any challenge to the constitutionality of statutory provisions in relation to elections had to be by way of petition to the High Court pursuant to Article 163 of the Constitution. The Court, however, allowed the appeal by the 7th and 8th respondents, holding that the High Court's jurisdiction is limited in judicial review proceedings in an ongoing election process and does not permit an interpretation of the Constitution during this process. The decision of the Court of Appeal ultimately paved the way for the declaration of the results of the election by the chairperson of GCOM on August 2, 2020. The said results were published in the Official Gazette on August 20, 2020 and are now challenged by this petition. It must be noted that there was a bit of inconsistency in the reliefs sought by the petitioners as stated in the petition, the written submissions, and by the conclusion of the oral arguments. The prayer for reliefs was amended in part as a result of clarification sought by the court during the oral arguments. Then also based on the oral arguments, particulars and original reliefs sought were amended. In particular, the petitioners claim at paragraph 11 of the particulars that the regime created under Order 60, which was purportedly in pursuance of Section 22 and Article 162, was itself ultra vires and inconsistent with Article 163 and not 161A as stated. And given the relief sought, which appeared to rely on Order 60, although not stated in the petition, it was submitted that this was a claim in the alternative, so that if Order 60 was found to be valid, then the petitioners claimed that GCOM did not comply with this order. It was stated that the petitioners were abandoning their claims for relief that relied on a contravention of the National Registration Act, as amended by the Local Democratic Organs Act 1980 and Elections Regulations 1964, as these pieces of legislation have nothing to do with this case. The relevant constitutional and statutory provisions are Article 62, Article 161A. Well, I mentioned that because that was stated in the petition, but it's not really relevant to the petition. It speaks to the Secretariat of the Commission. Article 162, which speaks to the functions and powers of GCOM. Article 163, which allows for the filing of elections petitions and the determination of challenges to elections by the High Court. Section 22 of the Election Laws Amendment Act and Section 23 of the Election Laws Amendment Act. Contentions of the petitioners. The petition and the submissions on behalf of the petitioners vacillated between the two limbs of Article 163(1)(bi), whether the election was not lawfully conducted or whether an unlawful act or omission affected the result of the election. And this is borne out in the reliefs that were sought. In the petition, it is the contention of the petitioners that, quote, the elections were unlawfully conducted and or that the result of the said elections, if lawfully conducted, were affected or might have been affected by unlawful acts or omissions on the part of GCOM, end quote. It was contended that, quote, the elections results as delivered by GCOM in pursuance of Section 99 of the Representation of the People Act were not lawfully conducted, end quote. However, of importance are the oral submissions wherein Mr. Jeremy asserted and confirmed that the petitioners were relying on the first limb of Article 163(1)(bi), that is, they seek a determination whether the election was lawfully conducted because of the reliance on Section 22 and Order 60, which they contend are unconstitutional. The grounds upon which the petitioner rely in support of these contentions can be encapsulated as follows. 1. Section 22 is unconstitutional, and by extension, Order 60 is invalid, null, void, and of no effect, as being inconsistent with Article 162 of the Constitution and the Representation of the People Act. 2, the electoral district declarations submitted by the returning officers could not have been set aside to permit the declaration of results based on certificates of district tabulation for the 10 electoral districts which are not recognized by the RPA, or Representation of the People Act. 3, GCOM's actions were unlawful and encroached upon the High Court's jurisdiction under Article 163 of the Constitution, which gives the Court exclusive jurisdiction to determine questions as to the validity of elections. In noting that the Constitution, the RPA, and the ELAA detail the powers and functions of GCOM, it is their argument that GCOM acted in excess of its jurisdiction and in contravention of the Constitution when it issued and acted on Order 60 pursuant to Section 22. It was submitted that by enacting Section 22, Parliament violated the constitutionally accepted doctrine of the separation of powers and abdicated its legislative function to GCOM, allowing the Commission, by virtue of a mere order, to amend the provisions of the RPA and thereby disregard the declarations of poll submitted by the returning officers. A number of authorities from India were cited, and I do refer to them later on. As regards the case of Astafan and Control of Customs, in the oral submissions it was acknowledged that it correctly stated the principle that the executive could delegate lawmaking functions, but that this had not been done within the context of the proper guidelines, for which there were none in this case. It was highlighted that by Article 160 of the Constitution, Parliament is vested with the exclusive authority to enact legislation with respect to the electoral system. Though it was emphatically submitted that this power is non-delegable, and consequently Parliament could not delegate its legislative power to GCOM or any other entity, it was submitted that while the law recognizes the possibility of the narrow delegation of powers to make subsidiary legislation for the implementation of policy, the unacceptable wide effect of Section 22 is such that GCOM can of its own volition set out its own unmonitored policy with respect to the conduct of elections. This permitted the Commission to have an unfettered discretion to amend laws, to wit the RPA, by a mere order for what in its sole discretion it deemed to be necessary or expedient to remove difficulty. This, it was argued, is indefensible and must not be allowed. It was further submitted that Section 22 could only be limited to future difficulties and not difficulties which would have arisen in relation to completed acts and transactions, especially where those acts and transactions were by election officers under the RPA, which would have given rise to accrued rights. Thus, Section 22 could only act prospectively and not retrospectively. Further, Section 22(2) empowers GCOM to amend laws even when Parliament is dissolved. Order 60 was promulgated while Parliament was dissolved. Therefore, there was no true parliamentary oversight of GCOM's exercise of Parliament's law-making power, which was purportedly delegated to the Commission. As a consequence of the submissions as regards the invalidity of Section 22 and by extension Order 60 which flowed therefrom, it was submitted that the declarations made by the returning officers could not be set aside. It was contended that by setting aside the declarations, GCOM had also acted in contravention of Section 84 of the RPA, by which only the returning officers are empowered to make declarations of results for their respective districts. Further, pursuant to Section 96 of the RPA, the CEO, that is the Chief Election Officer, could only rely on these declarations in the preparation of his report to advise GCOM on the final results of the election pursuant to Article 177 of the Constitution. As such, any decision of GCOM that was contrary to these provisions amounted to a violation of the RPA and a usurpation of the jurisdiction of the High Court pursuant to Article 163. In this regard, it was never open to GCOM to use its powers under Section 22 and Article 162 to seek to overcome difficulties which required it to encroach or overreach or encroach upon the exclusive jurisdiction of the court under Article 163. This is to say, GCOM could not amend the RPA by a mere order and in effect usurp the powers of the High Court under Article 163. Further, in construing Article 162, it has to be borne in mind that this article states that it is subject to the Constitution. Therefore, GCOM is subject to Article 163, which provides for the determination of issues herein by way of election petition. Thus, it is the High Court that is to inquire into and determine any difficulties that may have arisen with the election and not GCOM. It was not for the Commission to set aside the declarations of poll for the 10 electoral districts. In support of these submissions, the petitioners cite Section 52 of the CCJ decision in Ali and David. Also cited was the decision of Justice Holder, delivered on the 31st of March 2020 in Jagdu and Holidar and Mingu in relation to the declarations made by the returning officers on March 13, 2020. In this case, His Honor ruled that the declarations of the returning officer could only be set aside by an election petition. In responding to the submissions of the respondents that placed reliance on previous pronouncements of the courts as regards Order 60, especially that of the CCJ, the petitioners urged that these statements were made obiter dicta. It was argued that in none of the decisions did the courts consider or pronounce on the constitutionality of Section 22 or Order 60. Indeed, the petitioners reminded that the fourth respondent and the Attorney General had argued successfully in the previous cases that the constitutionality of these provisions had to be challenged by way of election petition. As such, they disagreed that the issue of the constitutionality of these provisions is res judicata. In further countering the submissions for the respondents, it was advanced that the conduct of the elections amounted to a sham and travesty because of the egregious breaches of the law by which and under which the recount was conducted. Thus, the election must be vitiated pursuant to Article 163(1)(bi) on the basis that the election has not been lawfully conducted, particularly as regards the provisions of the Constitution, and that the provision being disjunctive, there is no need for the petitioners to prove that the results have been or may have been affected by any lawful act or omission. Hesbon Amondi and Independence Electoral Boundaries Commission, a case from Kenya in 2018, and Morgan and Simpson, 1974, were cited in support of the contention that if an election was conducted so badly that it was not substantially in accordance with the law as elections, the election is vitiated, irrespective of whether the result was affected or not. The petitioners say that the March 2 election falls within this category, as the results came after there were egregious departures from the statutory requirements and legislative framework pursuant to Order 60, so that any recount had to be sanctioned by an election court pursuant to Article 163. In the circumstances, it was submitted that there was no need for evidence in relation to whether the results of the elections were effective, since the unlawfulness of the conduct of GCOM in not adhering to the RPA meant that the election was vitiated in any event as a matter of law. Mr. Jeremy, for the petitioners, in his oral submissions, accepted that there were difficulties regarding the elections, though maintaining that such difficulties had to be addressed by way of an election petition and not by Section 22 and Order 60. It was further stated that the undertaking to conduct the recount, which was given to the court by the chairperson of GCOM, was therefore unlawful. And while the petition itself and the submissions relied on the unconstitutionality of Section 22 to deem Order 60 invalid, Mr. Jeremy further argued that Order 60 of itself was unconstitutional. In addition, though from the inception, Mr. Ford and later Mr. Jeremy maintained a reliance on the invalidity of Section 22 and Order 60 in the oral arguments to support the claim that the results were affected, Mr. Jeremy referred to the difference in recorded votes cast in the official gazette dated August 20, 2020 as against that declared by the CU in a letter and report dated July 11, 2020, which were exhibited, to submit that indeed there is evidence that reliance on Order 60 affected the results. Submissions for the respondents. The submissions of the first and fourth respondents and the Attorney General were similar for the most part. They contend that while the petitions rely on both grounds of Article 163 in the petition, their submissions only address one of the limbs, that the election was unlawful due to an unlawful act or omission, to wit, reliance on Section 22 to issue Order 60, when Section 22 is unconstitutional as violating the separation of powers. They state that if this argument is rejected, then the petition has to be dismissed. It was submitted that pursuant to Article 162(1), GCOM had the power to issue Order 60. As the recount order, it was issued in order to resolve irregularities, anomalies, and discrepancies before declaring the results of the elections, which, as required by the RPA, and the Constitution. It was urged, applying Ministry of Home Affairs and Fisher and the Attorney General of Guyana and Cedric Richardson, that the court should adopt a generous, liberal, and purposive approach in interpreting Article 162. It was advanced that while Section 22 could stand by itself, it could not be functionally separated from Article 162(1)(b), as it served as a means of implementing this subarticle, so as to resolve or remove the difficulties and impasse which prevented the impartial and fair application of the law. Further, it was reiterated that Section 22, which speaks to an order and not to the enactment of substantive legislation, permitted GCOM to issue such instructions and take such action in order to complete the discharge of its constitutional mandate of declaring the final results of the election. Therefore, Section 22, whether singularly or in the context of Article 162, permitted the making of an order to remove the difficulties which prevented or hindered the application of or compliance with the Constitution and the RPA. The respondents canvassed that Order 60 was not meant to amend the law and did not amend the law, since it was issued to remove difficulties. In this regard, Order 60 sets out a procedure for the recount of ballots, a power that GCOM possesses under the RPA. The power as exercised under Section 22 was within the general framework of the RPA, which is to secure an election result. Ford and McEldowney, 1969, was cited. Order 60 made provision for the determination of the results of the election by way of counting the ballots utilizing a different procedure from that outlined in the RPA. This amounted to a modification for this particular election and therefore does not amount to an amendment of the law for all purposes. Thus, what has been done does not support the petitioner's submissions that Section 22 amends the RPA. Also relying on Astefan, it was submitted that in any event, there was sufficient control, prescribing guidelines, and circumspection in Section 22 itself in keeping with the conditionalities of delegated legislation. Thus, Parliament did not surrender its powers by delegating its functions, given that elections only take place after dissolution of Parliament. While the first respondent advanced that if the court were to find Section 22 is unconstitutional, that Order 60 could still have been made pursuant to Article 162(1)(b, the fourth respondent submitted that if Order 60 is found to be unconstitutional, then in the absence of evidence to prove that the result of the election has been or may have been affected, the election cannot be ruled to have been affected by such an unlawful act. This is because there was substantial compliance with the RPA. The fourth respondent also submitted that if at all it would be the words, quote, including the amendment of said legislation in Section 22 that could be unconstitutional, and if so found, that they be severed, preserving the rest of the section. Section 23(1) of the ELAA was relied on by the Attorney General in urging that since Order 60 was promulgated under Section 22(1), in effect it is a provision of the ELAA, and therefore if there is any inconsistency between the ELAA and the RPA, the provisions of ELAA will be construed as modifying the RPA by virtue of this section. Hence, the permissible modification of the RPA by Order 60. Mr. Mendes, for the fourth respondent, stated that the RPA was not modified and that what occurred was the utilization of another mechanism to count the votes. As a consequence, the respondents urged that Order 60 is intra-vires and was lawfully issued, and that Section 22 does not offend the Constitution. Additionally, even if Section 22 is ruled unconstitutional, without the aid of this section, GCOM is lawfully empowered to promulgate Order 60 or any such order pursuant to Article 162(1)(b). In the alternative, the respondents also submitted that pursuant to Article 163(1)(bi), there are two grounds for the nullification of an election, and they cited Petrie and the Attorney General. They submit that in considering whether the election was unlawfully conducted, applying Leandro and Jonas, the issue would be whether the petition, including particulars or evidence, shows that the alleged non-compliance was such that the election or the recount was a sham or a travesty. It was contended that the petitioners have failed to plead or produce evidence to show that Order 60 and the recount were shams or travesties, which denied or deprived the electors of their votes cast at the elections. The respondent urged that in election law, a mere breach of the law or constitution is not sufficient to set aside an election or recount. Therefore, a person who alleges a breach of the law in relation to an election or recount is required to plead that 1, the extent of the alleged breach of law was such that the election or recount was not in substance a legitimate election or recount, but a sham or travesty, or that 2, the election or recount was conducted in such a way as to have led to the substantial disenfranchisement of electors. They relied on a number of cases, Evo and Super, Woodward and Sarans, Frampton and others, and Pinard, Esther Pereira, and Atherton and Fergus. In this vein, the respondent stated that all the recount process did was to recount ballots cast on voting day. There is no evidence before this court impugning the ballots that were recounted. There is no evidence of any variation between the first count, which took place at the end of the poll, and the count which took place under Order 60. Concomitantly, even if it were to be found that Order 60 and the recount were unlawful, there is still no evidence that either or both of them materially affected the results of the elections. I turn now to the constitutionality of Section 22. In the interest of clarity, it must be highlighted that an election does not only refer to elections or polling day. When one speaks of elections, this refers to the entire process or election period that commences from the proclamation of the date of the election and extends through to the final declaration of the results. Thus, it is anything done during this process which affects the conduct or results of the election that can be subject to challenge by way of an election petition pursuant to Article 163. The 3 pillars of the petitioner's submissions, as I outlined earlier, really support one conclusion: that the conduct of the election was not lawful because of the reliance by GCOM on Section 22 and Order 60, which provisions are unconstitutional. In Esther Pereira and Chief Election Officer, Justice C.M.C. Singh examined Article 163 and formulated a 2-pronged approach in determining whether an election should be vitiated. Her Honor concluded that a distinction must be made as regards 1, the unlawful conduct of an election, and 2, an unlawful act or omission which has affected or may have affected the result of the election. Her Honor posited as follows: in the former case, the relevant issue concerns the conduct of an election, while in the latter, the relevant issue concerns the result. In the former case, the unlawfulness is confined to the conduct and has nothing to do with the result, while in the latter case, the unlawfulness, act or omission, has everything to do with the results of an election. GCOM utilized and relied on Section 22 and Order 60 in the conduct of the elections. The authorities are clear. The constitutionality of Section 22 and Order 60 fall to be considered in an election petition. Thus, while the Court of Appeal, by its decision in Moore, facilitated the recount to proceed, the Court also clarified and confirmed in Misenga Jones that the constitutionality of the statutory framework to do so was for an election petition. Relying on Esther Pereira, the petitioner's submissions in reply, and Mr. Jeremy's oral submissions, I have determined that the petitioner's challenge to Section 22 and Order 60 falls to be decided under the first limb of Article 163(b)(1)(bi), that is, it is concerned with whether the election was lawfully conducted. Pursuant to Article 62 and 162, GCOM's functions are to conduct elections pursuant to the Constitution and any Act of Parliament. Importantly, in carrying out its functions, it is GCOM's responsibility to independently supervise elections. So in carrying out its constitutional mandate and in implementing the relevant legislation, GCOM is to exercise general direction and supervision and have administrative conduct of the elections of members of the National Assembly. Significantly, Article 162(1)(b) stipulates that GCOM can issue instructions and take such action as necessary or expedient to ensure impartiality, fairness, and compliance with the Constitution in any act of Parliament. Such acts of Parliament would be the RPA and the ELAA. In this regard, GCOM has to ensure that its officers and staff and others who exercise powers or perform functions regarding the administrative conduct of the elections carry out its mandate. In my view, the constitutional mandate is very wide and has to be given a purposive construction. And this, as explained by Sir Dennis Byron, former president of the CCJ, in Cedric Richardson. It is an accepted principle that courts should be generous in their interpretation of constitutions. The court should not be overly literalistic and restrictive, but should give effect to the meaning of the Constitution. While Article 62 enshrines the independence of GCOM as confirmed by the decision of the Court of Appeal in Moore, Article 162(1)(b) gives GCOM wide scope to discharge its functions as detailed in the said article so that it can ensure and deliver a lawful, fair, and credible election as required in a democratic society. In this regard, it has a concomitant responsibility to resolve any difficulties that arise during the election process. So in consonance with Article 162, Parliament enacted Section 22 as one of the provisions of the ELAA. Indeed, when one reads the ELAA, it addresses a number of issues that had arisen regarding elections, including those that resulted from the constitutional reform process and the issue of identification cards that was the subject of the Esther Pereira petition and decision. By enacting Section 22, Parliament clearly envisaged a responsible commission which, with the benefit of operational institutions, would best be able to address the needful during the election process. This, to my mind, must obviously include addressing difficulties or challenges that may arise. Were there difficulties in this election? Apart from what has been stated in this petition, the various cases that have wended their way through the courts clearly indicate that there were difficulties. The difficulties encountered are encapsulated in the judgment of the full court in Jagdeo and Moore, and I have quoted from the decision. I've concluded that Section 22 is an implementing provision to operationalize Article 162 so that GCOM could exercise its functions in the management of the election process. This is to say, Section 22 buttresses Article 162(1)(b) and provides a framework for the implementation of this sub-article. It therefore falls within the four corners of this provision of the Constitution. And while appreciating the decision of the Court of Appeal regarding the jurisdiction of the full court in Moore, I nevertheless think that the court succinctly explained Article 162 and Section 22 in Jagdeo and Moore at paragraphs 71 and 72, which I have quoted. Section 22 can be likened to the National Validity of Election Act, Chapter 104, which operationalizes Article 163 regarding the procedure in relation to election petitions. I do not accept the submission that the power to modify the law can only be futuristic, because this would not address difficulties that would have arisen, a situation that must have occurred in the past. The provision authorizes action to remove difficulty. Therefore, it is meant to allow for difficulties that have already occurred to be addressed. While GCOM could no doubt seek to issue an order in contemplation of difficulties that may arise in the future, I do not consider that it is logical that Parliament would mean that GCOM could not address difficulties that had already occurred. I am fortified in this view because Section 22 allows GCOM to issue an order during a period of 3 months after the election date. I do not consider that Section 22 offends Articles 65 and 170 of the Constitution, which provide for the legislative power of Parliament and the mode of enacting legislation, respectively. Article 65(1) provides for Parliament to make laws for the peace, order, and good government of Guyana. The ELAA, which includes Section 22, is an enactment that so provides. Article 170 states that subject to Article 164, which specifies how the Constitution can be amended, the power of Parliament to make laws shall be exercised by bills passed by the National Assembly and assented to by the President. The ELAA was passed by the National Assembly and assented to. Therefore, prima facie, there is no contravention of this article. Chancellor Messiah explained the concept of peace, order, and good government in the case of Agent Muhammad Ali, 1997, 41 West Indian Reports 176 at 190, which I have quoted. There is nothing in Articles 65 and 170 that restricts or prevents Parliament from enacting laws which permit the delegation of its legislative function. Indeed, many pieces of legislation permit the issuance of regulations by ministers or the entities they govern so as to properly implement the legislation. The issue would be whether the regulations or such subsidiary legislation falls within the parameters of the governing substantive legislation. I hold that Parliament did not abdicate its lawmaking responsibility to GCOM when it enacted Section 22. In this regard, the learned authors of Fundamentals of Caribbean Constitutional Law, citing Astefan and Controller of Customs, made the following observation on Parliament delegating its powers. There is no strong separation between legislative and executive power in the Anglophone Caribbean. While the power to make laws is constitutionally vested in Parliament, there can be a voluntary redistribution of powers. And here I cite Chief Justice Flossack in Astefan at pages 157 to 158, Hosbury's Laws 5th edition, volume 96 at paragraph 658, the Queen Public Law Project and Lord Chancellor 2016, Re Delhi Laws Act 1912, Devidas Gopal Krishnan and the State of Punjab. I've also cited the case that was relied on by the petitioners, Kunwar Ragarai Partap Singh and the Chief Election Officer, a 1998 case from India. And I do agree with the quotation cited from that case. However, in relation to the Singh case, I consider that the factual situation is different. In the case at bar, Section 22 provides specific guidance. In Singh, there is no legislation that guided the Election Commission regarding supplementing the gray areas, as the court described it. In Singh, the constitutional powers conferred on the Commission did not permit it to issue oral advice or oral direction to exclude the petitioner from the district during the election. The court noted that an oral direction was not envisaged in the scheme of governance which provided for adherence to the rule of law. The court considered that an order by the state government or a written direction from the Elections Commission would have been necessary in order to validly restrict the presence of the petitioner in the district. Thus, the court appears to have contemplated that orders could have been issued by or at the behest of the Elections Commission to supplement its constitutional powers. In this regard, this case supports the respondent's contention that Order 60 could have been issued pursuant to Article 162 without the need for Section 22. So I do not see how the Singh case assists the petitioner's submissions that if Section 22 is found to be unconstitutional, it means that Order 60 could not flow directly from Article 162. However, as I will address shortly, I do not agree with the position of the respondents that Order 60 could have flowed directly from Article 162. Applying the principles from the Indian cases and the reasoning of Chief Justice Flossack, I hold that the power as set out in Section 22 is clearly and sufficiently circumscribed so as not to run afoul of the doctrine of separation of powers. The conditionalities of delegated legislation, which are evident in Section 22, are that A, it authorizes only the making of subsidiary legislation, in this case Order 60. B, the power is only applicable when it appears to the Commission necessary or expedient for removing any difficulty. C, once Parliament is in session, the order must be subject to a negative resolution of the National Assembly. D, the order cannot be made after the expiration of 3 months from the date of an election. And E, The only time this power is without the supervisory jurisdiction of Parliament is when Parliament is not in session, and that time is limited to 3 months from the date of the election. In considering whether legislation or a provision is unconstitutional, it is the challenger to prove the unconstitutionality. This is because there is a presumption of constitutionality, and this was highlighted by Chancellor Messiah in Mohammed and Ali. My analysis of the authorities cited has led me to the ineluctable conclusion that Section 22 is not ultra-virus the Constitution, and I so hold. There has been no violation of the doctrine of separation of powers. Section 22 is meant as an aid to the process so as to permit a determination of a result. It does not permit a usurpation of the High Court's jurisdiction under Article 163 at all. Section 22 provides the parameters for its efficacy, and the power granted therein is not arbitrary. It includes sufficient mechanisms to establish that Parliament did not surrender or abdicate its powers. Thus, I hold that there was a lawful delegation of power as provided for in Section 22 so that GCOM could independently and properly control the election process to completion. I turn now to the Constitutionality of Order 60. Initially, there was no specific complaint by the petitioners regarding Order 60, except that it flowed from an unconstitutional Section 22. Based on the oral submissions, it was canvassed that Order 60 is itself unconstitutional. I am of the view and hold that just as Section 22 allowed for the implementation of Article 162, Order 60 in turn operationalizes Section 22, providing the mechanism for GCOM to address the difficulties that had obviously arisen as regards the declaration of the results. Additionally, Section 23(1) of the ELAA is relevant to a determination of this case. The side note for Section 23 states, overriding effect of this Act. This subsection, which was not addressed by the petitioners, specifically provides that if there is inconsistency with any of its provisions with the RPA and the National Registration Act, the ELAA shall be construed as amending or modifying these legislation. Thus, Section 23 confirms that in the restricted circumstances to address difficulties as provided for in Section 22, Section 22 permits the amendment of the RPA and the NRA. So an order could have been issued by GCOM that would or could have resulted in the amendment of these acts. Although Section 22, within the parameters outlined in it, permits the amendment of legislation by an order, I agree with the submissions for the respondents as Order 60 did not amend the RPA. The RPA remains as originally enacted. Order 60, as promulgated under Section 22(1), can be construed as simply modifying the RPA to provide a mechanism to allow for the recount to be conducted by expanding the recount provisions in this Act. It simply sets out a procedure for the recount of ballots, a power the GCOM possesses under the provisions of the RPA. So in issuing Order 60, GCOM did not purport to amend any legislation. If, for whatever reason, any person exercising powers or performing duties pursuant to Article 162, 1B, goes rogue, so to speak, and does not follow the required provisions of the RPA and the directions of GCOM, it cannot be that GCOM must await the results they provide, must accept the results they provide and await the outcome of an election petition. As Mr. Astafan stated, GCOM simply could not accept its officers not complying with the requirements to complete the election process, but proceed regardless. This is why Parliament gave it permission to deal with difficulties so that the election process could be completed. Thus, I do not entirely agree that GCOM could have issued Order 60 in the absence of the enabling provision, such as Section 22, which established the legal parameters of its ability to do so, as discussed in my analysis of the constitutionality of Section 22. Given the difficulties, it does appear that it would not have been prudent for GCOM to declare the results in the peculiar circumstances that attended the completion of the process of the March 2, 2020 elections. And as noted by Justice of Appeal Passad and Masinga Jones, citing Alufa Alu, Prime Minister and Governor General, 2001 case from the Solomon Islands, GCOM cannot be expected to act on advice known to be unlawful or lacking in legitimacy and act on it. Thus, I've concluded that Order 60 is not ultra-vires the Constitution or Section 22. A combination of Article 162(1)(b) and Section 22 conferred a power on GCOM to issue this order if GCOM considered it necessary or expedient to ensure impartiality, fairness, and compliance on the part of persons exercising powers or performing duties on its behalf as regards the election process and the declaration of the results of the election. The CEO and the returning officers are among the persons contemplated by Article 162(1)(b). It is in this overall constitutional and legal context that the actions of GCOM have to be assessed. If there were no difficulties, then the action of GCOM would be ultra vires. But as noted earlier, the petition highlights what is well known from the cases that have been filed before in relation to the March 2, 2020 election, that there were difficulties in the completion of the election process. GCOM, as part of its core function, pursuant to Articles 62 and 162, had an obligation to complete the election process and therefore had a concomitant obligation, duty, and responsibility to address such difficulties to achieve this. Order 60 was an aid in the election process, permitting a determination of the result. It is itself limited by its provisions. Order 60 is meant to facilitate GCOM's mandate to declare the final results of the March 2, 2020 election given the prevailing circumstances. The order therefore merely modified the RPA and provided an alternative mechanism for arriving at the final results of these particular elections, given the difficulties GCOM considered necessary to overcome in completing the election process, which it was mandated to do pursuant to Article 162. Section 84 of the RPA provides for the returning officers to add up the votes recorded in favor of the list and publicly declare the votes. Then, pursuant to Section 89, the returning officers deliver their returns to the CEO for the final tabulation of the votes so that a report on the result could be prepared pursuant to Section 96 for submission to GCOM. In addition, Section 84 provides or makes provision for addressing errors and mistakes in statements of poll, as well as requests for recounts. A recount of votes is therefore not alien to the election process. Section 88 further provides that a duly appointed candidate or counting agent present when the counting or any recount of votes is completed may request the returning officer to have the votes recounted or again recounted, but the returning officer may refuse such request if, in his opinion, it is unreasonable. What is clear is that by Article 177 of the Constitution and Sections 96 and 99 of the RPA, it is GCOM that declares the final result, and not the returning officers or the CEO. GCOM is meant to be and has to be in control of the process until satisfactorily completed. This is the ultimate power the GCOM has pursuant to Article 162. Thus, Order 60 does not confer any additional powers on GCOM, but simply alter the procedure to arrive at the result that the RPA requires, the result of the election. While the procedure was different, the aim and objective were the same: to count the ballots and determine the votes cast for the list of the political parties who contested the election. I consider and hold that Order 60, and for that matter its enabling provision Section 22, did not and have not usurped the jurisdiction of the High Court under Article 163 to determine whether an election was lawfully conducted. These provisions simply facilitated the process for the completion of the election so that whatever challenge could be mounted and pursued could be done by way of election petition. While appreciating that the CCJ did not specifically pronounce on the constitutionality of Section 22 and Order 60 in Ali and David, the Court emphatically explained Order 60 in paragraphs 37 and 38, which I have quoted. In my view, the CCJ applied a purposive interpretation in coming to its conclusions about the effect of Order 60, when the court stated that it did not amend the Constitution. I also cite paragraph 40 from the CCJ decision. I do not consider that these pronouncements are obiter dicta. They are part of the reasoning of the CCJ in its consideration of the David case. As such, these pronouncements are binding on this court. As I ruled in Masinga-Jones, the CCJ had in fact accepted that Order 60 was required to resolve the political impasse and provide a transparent method for a national recount so as to complete the election process. And as the Court of Appeal in the Jones appeal, the Court of Appeal in the Jones appeal came to a similar conclusion. Therefore, Justice Holder's decision that the declarations of the returning officers could only be overturned by an election petition was overtaken by events. It is only if Section 22 and Order 60 were found to be unlawful that these declarations would continue to have life. The CCJ clearly stressed that Order 60 did not create a new electoral regime. My interpretation of this pronouncement is that this order did not amend the elections legislation and confirmed the Apex Court's conclusion that it spoke specifically to the March 2 elections. Further, I note that at paragraph 46 of the CCJ decision in Ali and David, it was held that it is clear that under the legal infrastructure governing the election process, unless and until an election court decides otherwise, the votes already counted are valid votes and are incapable of being declared invalid by any person or authority. This supports the conclusion that all the recount process did was to recount ballots cast on election day, that there has to be evidence to impugn the prima facie valid votes cast so as to discount them from being recounted was firmly established in Ali and David at paragraph 47, where the court stated, whatever allegations of irregularity attended those votes, and we neither agree nor disagree as to the existence of such irregularities, must be adjudged by the High Court under Article 163, as was correctly stated by the chairperson of GCOM. At paragraph 23 of the submissions in reply on behalf of the petitioners, it is claimed that there were egregious breaches of the Constitution in respect of tampering with of ballot boxes once they were sealed, the counting and recounting of ballots, the personnel employed to do so, and the use of non-statutory documents to record and report the results. These claims seem to suggest a reliance in the second limb of Article 163(1)(b), that unlawful acts or omissions affected or may have affected the result of the election. Mr. Jeremy referred to a difference in the recorded figures for parties as disclosed on two of the exhibits. Exhibit A, the official Gazette of August 20, 2020, in which the results are declared pursuant to Order 60, and Exhibit D, letter from the CEO to the chairperson dated July 11, 2020, with a report from the CEO regarding his tabulation of the results. He utilized these to say that this shows that the result was affected by Order 60. With great respect, much more would have to be produced than a mere suggestion from the bar table. It is unclear what is the basis of the CEO's report as exhibited, more so as the CCJ in Ali and David had impugned a previous report submitted by the CEO, dated June 13, 2020. Further, the completion of the election was still in the throes of uncertainty on to the decision of the Court of Appeal in Jones on July 30, 2020. There are no particulars and insufficient evidence in this petition to support these claims. Therefore, there is no evidence to support the second limb of Article 163(1)(bi) that there were unlawful acts or omissions such as to affect the result. And I've included all of this for completeness. Then the letter Exhibit D, along with another dated July 2020, seemingly part of Exhibit I, suggests an ongoing challenge to the authority of the chairperson of GCOM. This is especially so when they are read in the context of the letters from the chairperson to the CEO that were also exhibited, in which requests were made for the submission of a report based on the recount. As I ruled in Masinga-Jones, which was confirmed by the Court of Appeal, pursuant to Section 18 of the ELAA, the CEO is subject to the direction of the Commission and is not a law unto himself. Thus, I cannot accept the contention that based on the evidence of this petition, the results were affected by GCOM's compliance with Order 60. A determination of allegations that there were irregularities would require evidence. Similarly, the contention of the petitioners that there was a breach of Order 60 would require evidence. The petitioners in this case have not produced any evidence to support any substantial breach of or non-compliance with the election laws, such as to affect the results. And as clearly stated through counsel, this petition was not relying on evidence in this regard. The petition, they said, is about a legal issue, whether Section 22 and Order 60 are constitutional or not. So ultimately, despite the relief sought, this petition does not rely on the second limb of Article 163b(1)(i) and Section 30 of the National Assembly Validity of Elections Act, Chapter 104, that there have been unlawful acts or omissions affecting the results. Indeed, evidence that there were unlawful acts or omissions, such as affected or may have affected the result of the election, has not been provided in this petition. Conclusion. I hold that in order to exercise general direction, supervision, and have administrative conduct of elections, GCOM had to ensure the lawful and proper implementation of the RPA in Section 22. This was done lawfully by GCOM via Order 60, enabling it to issue instructions and take action as appeared necessary and expedient to resolve the controversies as part of its responsibilities to complete the elections process by delivering the results. There was no breach or violation or non-compliance by GCOM with the Constitution or the law governing elections, such as to make the election a sham or a travesty as claimed by the petitioners. In a case such as this, one has to look to the Constitution for the raison d'etre of the ordinary or subsidiary legislation. In my view, as I have outlined, Article 162 so provides. As a consequence of my decision, there is no need to discuss what the position would be if Section 22 and/or Order 60 were found to be unlawful, and whether such unlawfulness was substantial or not, such as to affect the result of the election. So I hold that both Section 22 and Order 60 are intravirus. Neither provision offends the Constitution. They buttress these provisions to make them implementable. Given my conclusions, the complaint that the statements of recount replaced the declarations of poll made by the returning officers is now moot. Section 22 and Order 60 permitted the recount and thereby the utilization of related processes and documentation to produce the results of the election. As such, the petition is dismissed. The necessary certification will be issued pursuant to Section 32 of the National Assembly Validity of Elections Act, Chapter 104. In relation to costs, if not agreed within 28 days hereof, the parties are to submit applications for costs to be assessed by the registrar. There is a separate and consequential order that I have to make, and it is as regards the statements of poll and statements of recount that were lodged and are in the possession of the Registrar of the Supreme Court. As regards the orders made for securing the statements of poll and statements of recount, the order granted is further extended so that these documents are to remain in the custody of the Registrar of the Supreme Court until all appeals have been completed or a court orders otherwise. That's the decision of the court. Thank you.
Thank you very much, Your Honor.
Thank you very much.
Much obliged, Your Honor.